Welcome to the North Carolina Divorce Info Podcast, where we get answers to your questions about divorce in North Carolina.
Our guest today is Richard Waugaman. Richard Waugaman is a licensed family law attorney and certified mediator. He practices in Wake County, North Carolina, in both roles at Lesnick Family Law, where he is a partner. Richard Waugaman, welcome to NC Divorce Info.
Thank you for having me today.
So, we're going to talk today about divorce mediation. That is a subject that a lot of people have an interest in. It's a very well known. But before I get into divorce mediation, I just wondered if you could tell us a little bit about your law practice and yourself.
Yeah, certainly. I'd be happy to. So, I practice in Wake County, North Carolina, almost exclusively. Our firm name is Lesnick Family Law. It is a firm that my wife and I co-own and run together. We do exclusively family law, focusing on high conflict custody, domestic violence cases, but also some of the collateral issues to family law like mediation and parenting coordination. Both she and I are parenting coordinators in addition to attorneys, and then I am a certified family financial mediator.
So your wife is your partner?
Yes.
Were you guys lawyers and then you met because you were in family law, or was it the other way around?
We actually met in law school. She was a year ahead of me. She graduated, started her own firm, and then when I graduated, I started working with her and running the firm together with her, and we've been doing this for almost 7 years now together.
So you've always worked together?
Yes.
Okay, so you handle family law exclusively. In addition to divorce mediation, do you also handle traditional divorce cases as well as separation agreements and post-divorce matters, etc.?
Yes, we do pretty much exclusively family law. There's not really anything else that we handle, but we do the full gamut of family law cases, from negotiated separation agreements and parenting agreements that, no one ever gets into a courtroom. And then we do full high conflict litigation where you have trials and hearings that last multiple days. And, ultimately then a judge makes the decision. So we handle both ends of the spectrum and everything in between.
When I hear high conflict, I think of that movie from the 80s, I think, War of the Roses.
There are certainly a lot of cases that, we have that are very similar to that. A lot of domestic violence, a lot of child abuse, a lot of, people going back and forth and going at each other. So it can definitely, whatever you can think of as high conflict, we've probably seen it in some form or another.
Now, I think that our culture kind of has this preconceived notion or this cultural expectation that that's how divorce is supposed to be or often ends up. But it's not always like that, is it? And there are better ways, which would include divorce mediation, what we're going to talk about today.
Yes, absolutely. The vast majority of cases are not high conflict, and in fact, the vast majority of cases never even see the inside of a courtroom. The majority of cases do have some kind of settlement, and that's kind of the end of it, and it never goes in front of a judge. And that is a big preconceived notion that a lot of clients have when they come in the door, is that court is the only option. But there are a lot of options other than litigation and other than going to court. And for the majority of cases, those other options are actually the better option for a number of different reasons.
Well, let's talk about divorce mediation. What is divorce mediation and how does it work?
So with any kind of lawsuit that's filed, that's the process where you go into court, you go in front of a judge, and the judge makes the ultimate decision. And on the other end of the spectrum is, kind of settlement agreements where it's two parties, either with attorneys or on their own, who reach some kind of settlement and have it written up, and that's the end of it. And mediation falls somewhere in the middle, a little closer to the process of settlement between parties. So mediation is a method of alternative dispute resolution, which is just a fancy way of saying other ways to get settlements done and outcomes reached without having to go to court. And what mediation really involves, to give the giant kind of bird's eye view of it, is mediation is a process whereby, one party, either on their own or with their attorney, and the other party, either on their own or with their respective attorney, are in the same kind of place at the same time, not necessarily in the same room, but generally in the same kind of office complex. And there is a mediator, and that mediator's role is to help the two parties reach some kind of mutually agreeable resolution and outcome. So generally, you've got a husband in one room with his attorney, a wife in another room with his attorney, and the mediator is going to be going back and forth between the two rooms, conveying offers, talking about the issues, helping people see things in different lights and from different perspectives, so that everybody can come a little bit closer towards the middle and find that compromised outcome and resolution that everybody can be on board with and happy with, so that at the end of the day, you can have a permanent final resolution of issues without having to go to court, without having to give up control of your own fate, and without handing everything over to a judge who's going to make a global decision based off limited facts and information, and do that kind of sometimes against your will and against the wishes of anyone, because sometimes that is the result that happens in court, is you're going to get an outcome no one's happy with.
Right. So is this typically done in one day, or are there multiple sessions usually needed?
Generally, with any kind of divorce mediation and family financial mediation, it is going to be a one-day kind of thing. We start pretty early in the morning, and we go all day until things get done. And it's not uncommon for these to stretch well into the evening or into the night. I know I've had a couple that have gone past 11 o'clock at night. So you're there for 8, 10, 12, 16 hours trying to get all these things done and making sure you get all these things done. But you are done at the end of the day, and you walk out with some kind of signed agreement if you're able to reach an agreement, so that everything's done, and that's kind of the end of your court process. And in many instances, the mediation is really the end of the process, and at that point, then everything's resolved. You don't ever have to go back to court again, and you have these agreements in place and ultimately sometimes orders in place so that everything is done.
Now, that's the agreement that you're talking about that is written up at the mediation. That's not the divorce agreement. Does that become part of the divorce decree, or how does that work?
Yes, in many ways it can be. Different attorneys, depending on who the attorneys are involved in the mediation, will do things differently. You can go into mediation, you can sign and notarize a permanent separation agreement, which becomes essentially the conclusion of your divorce, in that it's the final controlling document that dictates everything from the day it's signed until the day everything in it is completed, which is, children turning 18,
okay,
child support ending, property support ending, and it's a permanent ending document.
So do they ever have to go to court?
Oftentimes, no, there is no court required. The only thing that would have to be done is the actual granting of an absolute divorce to end your marriage. But what that can be, the way that can work in North Carolina, because all the claims are treated somewhat separately, is you can file a very simple complaint for absolute divorce, which just says that which says that the parties have already resolved all of their issues, either within a separation agreement or through some kind of other court order, and the divorce doesn't affect or touch any of those provisions. So everything that you agree to and settle to in mediation essentially becomes your divorce decree. So the other option, in addition to a separation agreement, as far as an outcome of mediation, is some attorneys do like to do what are called consent orders. And consent orders are essentially, it's just a separation agreement written in a different form that then gets taken to the court, and the judge will sign off on it, and it becomes an official binding court order. So that does look a little more formal and a little bit more like an official divorce decree. But once the parties have signed all of those documents, they generally do not have to go to court, and the judge can sign it outside of their presence. But it does then become a valid and binding court order that has with it all the powers of contempt and all the powers of enforceability that any court order would have, that you would go to a hearing and get from a judge directly, at the end of the day.
Are the mediators, are they attorneys, or I know that they are neutral parties?
Yes. The mediator is a third-party neutral, so when I mediate, I make it clear to everyone that while I am an attorney and do have experience as an attorney, I'm not there acting as an attorney. I'm there solely as a mediator to help them reach some kind of resolution. The majority of mediators are attorneys, but they're not required to be. There's some mediators that are financial planners. There's some mediators that are therapists or have some kind of doctorate in counseling or things like that. The process for certification for a mediator is handled through the North Carolina Dispute Resolution Commission, and they have a set of criteria that you must meet in order to be a certified mediator, which includes taking training classes and an application process and observing other mediations done by other mediators. And the majority of people who go through that process and become certified are attorneys, but you're not strictly required to be an attorney. Most of the time that you're going to a mediator, it is going to be with an attorney, and I think there are advantages to having an attorney mediate for you, simply because they're bringing more personal insight and experience into the process of mediation from other cases that they've seen, which they can use to help kind of give some guideposts as to what kind of outcomes and situations you may be looking at and facing if you do go to court, that someone who's not an attorney may not have that personal experience to help with the mediation process.
Maybe you could talk a little bit about the role of the mediator. You talked about them going back and forth, but what is their role and what is not their role?
So the role of the mediator is not, as I mentioned, I'm not there as an attorney. I'm not there to give legal advice. I'm also not there as any kind of arbiter or any kind of judge, in that I don't get to make any final decisions. I have no control over the outcome as far as whether, a husband or a wife says yes or no or reaches some kind of agreement. Control is totally up to the two parties at that point as to whether they want to settle and whether they agree to the terms. What my role as a mediator is to help them focus on what is of primary importance to them, identify what is of primary importance to their spouse, and then help find solutions so that everybody can get the majority of what they want. I always tell everyone, you're never going to get 100% of what you want, and that applies to court, that applies to mediation. It just is a simple fact of divorce. But what you can do in mediation is hopefully get 85, 90% of what you want, which would also, in many ways, people will find out you getting 85, 90% of what you want generally allows the other person to get 85 to 90% of what they want. And at that point, that's where people can recognize and realize the benefits of settlement and get some kind of settlement, knowing that they may be giving up a little, but they're getting a lot more in return. So my role as a mediator is simply to help everybody kind of step back, look at the big picture, look at what the outcome that they have available to them in mediation, but also what the outcomes they may potentially be looking at in court, and figuring out what really is the best solution for both them and their families. Because at the end of the day, mediation is often the last chance that a lot of people have to have control over the outcome of the process. In many instances, people do mediation before they go to court, but often mediation is done as part of a court order that a lot of family cases, a lot of divorce cases do have required mediation at some point. So you're going to go into mediation, most of the way through the process. You're going to go through and you're going to go into mediation knowing that if you don't reach an agreement in mediation, your next step usually then is having a hearing in front of a judge. And once you get out of mediation and once you get into that courtroom, people don't recognize how little control they really have at that point. When you're in mediation, you still have the ability to say yes, you still have the ability to say no, you still have the ability to control and shape how the outcome is, as far as having some specific ability to dictate what the terms are. Once you get out of mediation and once you get into a courtroom in front of a judge, you're going to present your case, you're going to tell your side of the story, but the judge is going to decide everything. The judge is going to dictate, what the custody schedule is, what the amount of child support is, how the house is going to be divided, where, and it may be something that neither parent really likes what the judge does, but the judge is trying to do everything at a very limited snapshot of what this marriage and what your lives are, and make the best decision the judge can make in that moment, which may or may not be the actual best decision for you. In mediation, you still have that final ability to control your own outcome and decide, this may not be ideal, but this is a really good outcome for me and for my kids and for my family, and I can make this work. So I'm going to take control and make sure that I have the best outcome I can get, and not risk going to court and getting something completely off the wall that doesn't work for anyone.
All right, so who does this work for? Who would be the ideal candidate for divorce mediation?
Generally, what I say is that every case is a good case for mediation. Because mediation, again, is an opportunity to get everybody kind of in the same building, not necessarily the same room, but in the same arena, addressing these problems, addressing the issues, trying to get a resolution on everything. And it does take there is a little bit of pushing, there is a little bit of give and take that is involved, but ultimately every case that's going to end up in court, you could, I think, at least try mediation as kind of an effort to get it resolved one last time before you're going to turn everything over to a judge. And that doesn't say that every case is going to settle in mediation. And what it may be is that you may go to mediation and you may settle the majority of things. You may be able to reach an agreement on custody and child support and how property in the house is going to be divided, but you may not be able to reach an agreement on alimony. What that means, though, is that all of those other things are resolved and you only have to go to court on one thing, or you may resolve all the financial issues, and you may resolve the property division, but you may not reach an agreement on custody, so only custody has to go in front of a judge. But what that does, even if you only reach a partial settlement in mediation, is you do still have that control and ability to dictate those areas. And, as any attorney will willingly tell their client, the more you can settle, the less your costs are going to be, the less your uncertainty is going to be. And, that's another one of those big advantages to mediation is you're going to get in, you're going to be able to do it in a much more timely and efficient manner, and it's going to be significantly less expensive than going to court.
You mentioned control over the outcome as one of the benefits. What are some of the other benefits of divorce mediation?
There's a couple. Mediation is typically something that you can get set up and get into pretty quickly, especially if you're in an area where there's multiple mediators and you're not specifically wanting to do one mediator, but if you are trying to get into mediation, you can generally get into mediation pretty quickly. I can generally get people in to mediate with me usually within a couple weeks to a month or two. Whereas if you're trying to get calendared in the Wake County courts, oftentimes you're looking at a hearing date that's not going to be for 3, 4, or even 6 months, depending on what it is you're trying to calendar. So the litigation process is significantly longer as far as how much time it takes, where you can get into mediation and get it all done all at once. One of the other real benefits to mediation is mediation has a lot more flexibility in it. In mediation, we're able to do things based off what works for a husband and what works for a wife that may be atypical, and create a flexible kind of dynamic outcome and resolution that works for everybody. The court, just because of the number of cases they see and the limited time they have, you tend to get more static and predictable kind of outcomes that are done a certain way and that are a little more rigid. And, with the dynamics of a family and having children, there's so many moving pieces that flexibility of an outcome and of an order and of an arrangement tends to be something that in many cases is desirable and works better for people. But you're not necessarily going to get that individually tailored outcome in court just because it's more of a, repeat repeated process whereby the judge is hearing very similar things and making very similar rulings.
What about the negotiation component? Does that become part of the court record, the public record?
No. Generally, all negotiations and all settlement offers that are done in mediation are going to be confidential. So if you don't reach any kind of settlement, pretty much everything that you discuss in mediation as far as settlement offers, those can't be used against you, and those stay confidential, and they don't ever become part of the public record. Certainly facts and information that are divulged and discussed in mediation may come to light, but the mediation process itself, as far as negotiations and offers, that's all confidential. That all gets kind of sealed up and never mentioned again once mediation ends. And then in many instances where when you do reach an agreement, if you reach an agreement and you formalize and finalize that agreement through a separation agreement as opposed to doing some kind of court order, that separation agreement can actually be a private document that doesn't get recorded, doesn't get filed with the court, and all you do is file a notice to the court that says, hey, we've reached a settlement, we don't need to go forward anymore, but the specific terms of your settlement can stay completely confidential.
So there's certainly a benefit of a greater protection of your privacy over, say, litigated divorce?
Yes. I mean, once you go into litigation, everything is public record, and anyone can go down to the courthouse and pull your court file and read everything they want to know about your life that made it into the court record. And those orders are all on file and can be accessed by anyone who walks into the courthouse. With mediation, if you resolve everything through some kind of private agreement, one of the benefits of those agreements is that they can stay completely confidential and private.
Would you say that, I know that once someone's divorce is final, if they have kids, they're going to continue to be issues that need to be worked out, changes in schedules as the kids grow, and things like that. Do you find that folks who go through mediation successfully, are they less likely to end up in court in the future? Do they tend to stick with that when they have disagreements in the future?
I think there's a lot of people who ultimately, do come back to mediation because, circumstances certainly change as children get older. But I think one of the other things that happens with mediation is that you've shown two people who don't think they can agree on anything that there is a way for them to reach some kind of agreement. So what's going to happen is you've healed a lot of that damage and you've built back some of that trust so that people do think they can work together again, and they are able to resolve some of the minor things and some of the things as children change. And maybe they don't even have to go back to mediation just because they've gained some of that trust and some of those skills in order to reach an agreement and avoid court. But certainly I do think there is a decrease in hostility whenever you have resolution through mediation. And you also have less resentment, because if you go to court and, even if you go to, if you're the wife and you go to court and you get alimony, you may have your ex-husband may just be really upset about that still, and it becomes a thing of resentment that, he lost in court and he has to pay alimony, and it just kind of extends that hostility and that malfeasance between the two people. Whereas if you come to mediation and you reach some kind of agreement, even if you have a husband that's paying alimony or a wife that's paying alimony, depending on your circumstances, it's something they've agreed to. So there's not that hostility and that bitterness that goes along with getting a court order and forcing someone to do things, which not only decreases some of that emotional, conflict and that heightened emotion, but they're also more likely to follow and comply with an agreement or a court order that they've agreed to, as opposed to one that they fought and that the judge is making them agree to, which is going to decrease, any kind of contempt issues or non-compliance issues in the future. It may help cut down on some of those things.
Sounds like a better way to go all around to me.
That certainly is kind of my philosophy, is that with pretty much every case, you ought to at least try mediation, even if there's some issues that can't be resolved, and there very well may be. I think you can get the majority of things done. I think you can get it done quicker, cheaper, less emotionally, less with less conflict, and I think it works better for everyone in the long run. And in many cases, you're going to end up in mediation anyways, because there are a number of cases that have required mediation. So you may ultimately have to do it anyways. So to get it done sooner rather than later is going to decrease a lot of that conflict and decrease a lot of the costs, which is something that's, not secret that divorce can be very expensive, and doing everything you can to make sure that you're saving your assets for you and your family and maximizing that is not something to lose sight of.
That makes a lot of sense, to actually start out with the end in mind. As you said, if the majority of cases never end up in court, what would you say is the percentage of cases that reach an agreement without going to court?
It's hard to tell, and to give a specific number, just because there's a lot of cases that end up settling that never even make it to attorneys' offices.
Right.
But it's definitely the majority of cases don't have hearings because some kind of settlement is reached either between the parties privately or between the attorneys, or when you get into a mediation setting.
Well, I just think that if people understand that and they can go into it from the start with that in mind, the goal of we're going to reach an agreement, you could probably save a lot of resentment, time, bitterness, and money as well.
Certainly.
Okay, well, that's about all the time we have today. But I want to thank you for talking with us today about divorce mediation.
I appreciate the opportunity to come on and kind of shed a little bit of light on the process and give my little pitch for it, because I do think it is something that benefits, the majority of people, if not everyone, and is something that should be given serious thought and consideration.
Thank you, Richard.
Thank you.
All right. We've been talking today with Richard Waugaman about divorce mediation. Mr. Waugaman is a partner and licensed family law attorney and certified mediator at Lesnick Family Law in Wake County, North Carolina. You can learn more about Richard Waugaman in the show notes at ncdivorceinfo.com. I hope this was helpful. Thank you for listening, and we will see you in the next episode.
Thanks for listening to the North Carolina Divorce Info Podcast at ncdivorceinfo.com.